Hi, everybody. It's Jim Ostrowski back with another special edition of the Liberty Moving podcast. It's been a while, busy with the day job, usual excuse. So, just a quick word about the podcast. I am going to resume and do an active podcast. I've been inactive for a while. I've been on Locals, which is a subscription site. Excuse me. And I'm not going to, lie and say, oh, well, I'm just open with subscriptions. So that's been a disappointment. So what I'm going to do until I get more subscriptions, I'm going to hang out at YouTube and hopefully, draw attention to the videos that are already archived at Locals. And what I'm doing there is what I call Dr. Ostrowski's political class, where I'm going through all my books and sort of creating an outline of libertarian thought, theory, practice, and action. My hat was a little crooked there. So really interesting stuff. It's stuff you're not going to get anywhere else. You're just not, because I'm the most experienced political operative in the movement. I also have a foot in academia, and I also have a foot in the real world of law, politics, and courts, because I've been a lawyer for 37 years. So there's lots of great thinkers in the libertarian movement, but what I bring to the table is a fairly unique combination of experiences, skill set, and so on. And you're not going to get it anywhere else. So it's up to you to check out my material. Most people who check out my material like it and stick around. Most people who read my books like to read other books. It's just that I'm not like on TV. I don't suck up to the establishment libertarians, the billionaires, and so on. I don't suck up to the media, so I'm a little hard to find, but once you find me, I think you'll find that it's a good value. So today I just want to do a quick update on the Supreme Court case, which is we're going to get a decision on it on Monday. So about 6 years ago, we filed a case in federal court challenging the New York pistol permit law, or otherwise known as the Sullivan Law or the Sullivan Act. It wound its way through the courts, and on Thursday, we were conferenced in the Supreme Court. We don't know the results, but they announced on Monday. It's a long shot that we'll get in, but it's not totally impossible, because they've already taken a similar case. So what I'd like to do is sort of in honor of the occasion, and if we get denied on Monday, that's it. I'm done with Supreme Court probably forever. I do have a couple of cases in the pipeline, but it's tough to get into that court, and this was the biggie. So if we get in, it's full steam ahead. I'll keep you posted. And if we don't get in, then we're going to go to Plan B and pursue Second Amendment rights through other means. And speaking of which, the case lasted so long, I wrote a book about it. The Second Amendment works, and there is an action plan in there that does not rely on court action. And I'm not going to go into strategy today. We can talk about that some other time. But we filed a petition. We filed a supplemental petition in the Supreme Court. And by the way, if you want to read the documents, everything is online at the Supreme Court. They have a good website. Go to the Supreme Court, type in on the docket search, the word libertarian, and you'll find our case. It's the first one that'll come up. So you can read all the documents. So we filed our petition, which we worked really hard on. It was months and months of work. Then before the other side filed, because they asked for numerous extensions, well, 2 extensions, I filed a supplemental brief on the coup d'etat and burning out that one of the Second Amendment is that it creates political stability. A well-armed civilian population creates political stability and avoids coups d'etat. And wouldn't you know it, just shortly before we filed and continuing on after we filed, there was a coup in Burma that kind of illustrated all the points that we made in our brief, which is kind of interesting. Then the Attorney General of New York replied, and she ignored our reference to the coup d'etat, because of course she didn't have an argument to it. And I did a reply brief. I'm super busy. We're poorly funded. So basically, I had to reserve some time in the middle of the night to write the brief. But frankly, sometimes when you have not as much time, you kind of get it down to the essence. So what I'm going to do today, with your permission, I'm just going to quickly read the reply brief, because there's some good material in there. It kind of summarizes where we are, and it's not very long. So I figured let's do this podcast, and you'll have a sort of a record of where we are. And then Monday, if you follow my Facebook page or Twitter, or even here, I'll certainly do, if we get in the Supreme Court, I'll do another podcast on it, believe me. That'll be a huge day, biggest day of my career. So, but you'll have a good understanding of where we are and why this issue is so important. So, so here goes. This reply brief will be short, as we are anxious after a marathon 5-year, 10-month battle to finally have our arguments heard, and don't want to waste this chance, which we believe is our last, as the case has lasted so long. Our lead attorney is no longer engaged in litigation on a full-time basis. That would be me. We are acutely aware of the court's calendar and note the irony of the Attorney General's office, which has repeatedly dismissed our lawsuit as lacking any merit, not needing one but two extensions to grapple with our alleged weak arguments. We are certainly aware that this court has already agreed to hear a similar case, New York State Rifle and Pistol Association versus Corlett, involving, they're known as NYSERPA, involving the same issue of proper cause to public carry a firearm. We believe the court should also accept our case, raising the same and other important issues for the following reasons. Equal justice under law requires that litigants who lack financial resources be treated on the same footing as litigants represented by the wealthiest law firm in the world. True grassroots citizen activists should be treated the same in the courts as those affiliated with, sponsored by, and probably recruited by large gun groups. Our case makes more powerful arguments for the Second Amendment than were made in NYSERPA. Our broad-based challenge to gun laws, emphasizing the government tyranny argument, provides a much firmer footing for striking down laws against public carry than the narrowly crafted challenges of the past that led to this court's precedents being narrowly construed by many lower federal courts and completely ignored in New York State courts. Our case gives the court the opportunity to clarify the Second Amendment doctrine in such a way that will prevent the lower courts and New York State courts from ignoring this court's precedents for yet another 10 or 15 years, resulting in irremediable suffering of citizens deprived of the natural right to bear arms in these perilous times. We got in line first, and through no fault of our own, and because of the vast difference in financial resources between us and the litigants in NYSERPA, we were not able to file our petition until February. We had filed our case in the trial court on July 22nd, 2015. We filed an amended complaint on December 23rd, 2015. The case was submitted for decision on June 24th, 2016. The court issued a decision on January 10th, 2018. No criticism of the district judge is intended. However, that amounts to 1 year and 201 days, for which we bear no responsibility. The case was argued in the Second Circuit on February 20th, 2019. However, the court held the case pending resolution of NYSERPA versus New York City, a different case. The decision was issued by the Second Circuit on August 11th, 2020, once again representing a lengthy period for which we bear no responsibility, 1 year and 174 days. On this appeal, respondents' attorneys, who have had an occasion to answer these or similar arguments 7 prior times, see below, asked for and received extensions totaling 62 days. Thus, there were delays in totaling delays totaling 3 years and 72 days for which we bear no responsibility. Otherwise, our petition would have been filed well ahead of NYSERPA's. If this court grants our petition and consolidates our case with NYSERPA, no significant delays in scheduling would be required, as we can assure the court that we can meet any reasonable time frame, as we know our case well and will have additional attorneys available to support our small legal team. Let's see. So while the case was pending in the district court, we decided to try our luck raising similar arguments in New York state courts. New York courts responded to those arguments with indifference or disdain. In Choman v. Bowler, the court stated, finally, the petitioner's contention that the revocation of his pistol permit, excuse me, that was my case, by the way, violates his rights under the Second and 14th Amendments of the United States Constitution is without merit. Citations omitted. The Court of Appeals then dismissed the appeal sua sponte upon the ground that no substantial question is directly involved. In Gurnett versus Bargnesi, the appellate division again casually dismissed the arguments. Finally, quoting, to the extent that the contention is properly before us, we conclude that petitioner's contention that the revocation of his pistol permit violates his rights of the Second and 14th Amendments is without merit, citing cases. Court of Appeals then denied permission to appeal and add insult to injury, imposed costs of $100. Gurnett versus Bargnesi, citation omitted. We then filed a petition to this court on January 16, 2018. The Attorney General waived the filing of a brief, and the petition was denied on March 19, 2018. Same arguments. To summarize, this is the 8th time we have made similar arguments in 5 different courts. On only 2 occasions was there an extended discussion of our arguments. However, as noted in our petition in this court, numerous arguments we made were ignored. Now, the next section here, I point out that the Attorney General had misstated whether our petitioner, Murtari, had applied for a concealed carry permit. They actually had to correct their brief because he had, which means that we have standing to challenge the case. Point 2, the philosophy of this grassroots homegrown attack on New York's onerous pistol permit regime has been to attack the regime as a whole and all of its parts, and to do so because the actual purpose of the Second Amendment to deter government tyranny, as opposed to the purpose posited by those who oppose the right to bear arms, self-defense against street crime. The court has already accepted a case that seems to take a narrow approach and does not emphasize the government tyranny argument. There are 2 major problems with the approach taken by the petitioners in NYSERPA. First, by not leading with the government tyranny argument, they will be forced to battle proper cause on the poor battlefield of hundreds of confusing and tendentious cost-benefit studies about the risks and costs of public carry versus street crime. In sharp contrast, if deterring tyranny is the prime value served by the right to bear arms, the right to carry follows as night follows day. You cannot deter government tyranny when you cannot leave your home with a weapon. The second problem is illustrated by the case of petitioner Murtari. He sought a permit for home possession and public carry as stipulated by the respondents in the trial court. The licensing officer denied his application for good cause, thus effectively also denying his right to public carry without explicitly finding a lack of proper cause. Thus, even if NYSERPA's challenge to the proper cause requirement is upheld by this court, licensing officers who oppose the right to publicly bear arms could still thwart this court's ruling by denying permits entirely based on the other unconstitutional features of the regime, which we attack and NYSERPA does not. I know that's a little technical, but this is the way you argue cases. For these 2 separate reasons, the court should also accept this case in conjunction with NYSERPA as the only practical way to end the unlawful pistol permit regime, which has plagued New Yorkers for many decades. With violent crime and social turbulence on the rise and efforts to defund the police active in New York State, it is literally a matter of life and death that the court hear our case and strike the entire regime down as soon as possible. As we argued in the lower courts, the right to bear arms is distinguished from virtually all other constitutional rights in that its loss can lead to immediate death at the hands of criminals or tyrannical governments. As noted above, this grassroots effort has now raised the government tyranny argument 8 times in 5 different courts and never received a viable counterargument from our adversaries or one peep from any court. We believe this is because the argument is true and unrebuttable, and courts hostile to the right to bear arms have simply ignored it as they have no rebuttal to the argument. This pattern continues with respondents' brief that has only a cursory reference to it. In contrast to their dismissal of the argument in the trial court, they now appear to at least grant the argument a theoretical plausibility, yet they fail to explain how the New York pistol permit regime was tailored to respect the right of the people to bear arms, to preserve their sovereignty and liberty against tyranny, or cite any case upholding that regime that took account of the government tyranny argument in any way, shape, or form. The necessary corollary to ignoring the government tyranny argument, pretending it doesn't exist or isn't true and hoping it goes away, is ignoring the overwhelming evidence for it presented by the petitioners in this case. For example, we argue that the right to bear arms deters coups d'etat. Sadly, yet another coup in a poorly armed nation occurred just before we filed our petition. The coup in Myanmar, Burma, was the subject of our supplemental brief filed on March 9th, 2021. Sadly and tragically, Myanmar illustrates many of the points we made in this case. An unarmed population encourages coups and political instability. Coups often lead to mass murder and crackdowns on free speech and public assembly. Democratic processes are not sufficient to deter tyranny, as democracies often collapse. The crisis in Myanmar continues, and the death toll has risen to over 800. That was several weeks ago. Source: Associated Press. The latest tactic of the regime is to grab people out of their cars in broad daylight, precisely to intimidate the public. One man was shot by the regime while riding his motorcycle, and the ousted Democratic leader, Aung San Suu Kyi, was in the dock recently, charged with illegally possessing a walkie-talkie. It can happen here. It is fitting we close this 8th plea for our Second Amendment rights in 5 different courts over a period of 2,136 days by reiterating our request for equal justice under law. And here I quote Lewis Powell, former Supreme Court Justice, former president of the Bar Association, long deceased, gave a famous speech about 30, 40 years ago. Equal justice under law is not merely a caption on the facade of the Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that justice be the same in substance and availability without regard to economic status. And I'll skip the conclusion because it's just legalese. So that was filed in the court conference, the case. We'll find out on Monday if they're going to deny it, delay it to the next conference. There's only one more before the summer, or grant the motion and join, most likely consolidating our case with NYSERPA. It's possible they could do it separately and limit it to issues that are not an issue in NYSERPA, but the smart money says they're going to deny or defer until they rule on NYSERPA and then send it back to the Second Circuit. They're probably going to reverse the pistol permit law and the proper cause element of the law with the case they already have. So that's the situation. I see I'm going on about 20 minutes. I am going to get the podcast going again. Just have to figure out where it's going to be placed. If you want to, if you like my work, if you want to see more of it, go to Amazon, buy my books. I don't directly raise money. I do for political causes. We do some crowdfunding on lawsuits, but if you want to support my work, I avoid asking for donations, generally speaking. Very few exceptions. I don't go to rich people and ask them for money. I'm going to do this the old-fashioned way. I'm going to work hard and earn money in the marketplace by promoting these ideas. Use that money to support all sorts of direct action activities. So I've talked enough. Stay tuned on Monday at some point by 5 o'clock. We'll know where we stand. And follow me on Twitter and Facebook and subscribe to this podcast. I got to get to 1,000, the magic number. If check out what I've got at locals.com. And if you want to subscribe, feel free. Basically, I'm going to do a lot of work in politics depending on whether the money's there. I'm refuse to do fundraising anymore. Classic fundraising. I'm tired of it. So if people support my work through free market purchases, you'll get more. Otherwise, I'll go on and do other things like I'll drive an Uber or coach basketball or something, because I'm closing out my 37 years in the law. So thanks for your support. I want to thank everybody. I can't possibly thank all the people who made small donations over the years, even if I didn't get you a note or don't even know who you are half the time. I am very appreciative, because without that, I wouldn't even be able to stay up in the middle of the night and write a legal brief with very little sleep, because the electricity would be off. So everybody who helped, my sincere thanks. Lots more to come. You have no idea. Thank you.